Hello, everyone. Welcome. Excited to see, well, I can't see any faces, but the number of people apparently watching this going up, that's in itself very exciting. My name is Nketiah, or Ink Berko. I'm the policy organizer at the Democracy Policy Network on restorative justice, and I will be moderating today's exceptional panel on restorative justice for this year's Statehouse Futures Summit. So the current legal system fails to address the needs of harmed parties, offending parties, and communities writ large. Its failure is costly in more ways than one. However, as more and more communities and states are discovering, restorative justice is an alternative. So restorative justice, as many of you may be familiar with, is a conceptualization of crime as harm between parties instead of as an infraction against the state. It reorients our focus toward the people most impacted and also most able to address harms. And so today we'll be hearing from advocates who have devoted so much time and so much energy to documenting and fighting for the implementation of these lofty principles and putting them into practice. So on our panel, we have here Tarek Maassarani. Tarek is a restorative justice practitioner at the Honeycomb Justice Consulting Group. In 2012, he convened and coordinated the DC Alliance for Restorative Practices, a network of practitioners, police, educators, officials, and advocates aimed at supporting the integration of restorative practices in the district. Tarek has trained, advised, and otherwise supported the DC Office of the Attorney General, the Nevada Attorney General's Office, and the Virginia Commonwealth Attorney's offices in implementing restorative justice as an alternative to prosecution. He's also a visiting assistant professor at Eastern Mennonite University's Center for Justice and Peace Building. We also have Alicia Virani. And Alicia is the Rosalinde and Arthur Gilbert Foundation Director of the Criminal Justice Program at UCLA School of Law. There, she directs a policy and research agenda focused on decarceration efforts, with a particular focus on issues of pretrial detention and restorative and transformative justice. Alicia is also a co-chair of the Los Angeles Alternatives to Incarceration Pretrial Subcommittee, and as a staff attorney at the California Conference for Equality and Justice, created and directed a restorative justice community conferencing program that continues to divert LA County's youth out of the juvenile justice system each year. So with those introductions out of the way, I'll turn it over to each of our panelists to give an introductory statement. And we'll just start with Alicia.
Sure. Thank you so much for having me. Hello to all those who are watching. So I'll just start with a little bit of an overview of the work that folks in California are doing as sort of a lessons learned and jumping off point for restorative justice legislation. So as mentioned, my role is really to provide research and legal support to folks interested in thinking about how to legislate, how and whether we should legislate around restorative justice. And so late last year, a group of practitioners, restorative justice practitioners across the state of California, decided to start coming together to understand how they could be impactful in the policy arena and how they could be looked to as experts rather than traditional criminal legal system actors. And so, what I've learned from this process is that first, anyone trying to be engaged in policy and legislation in your state should really be looking first and foremost to people in communities with direct experience, both leading restorative justice processes, as well as people who have been participants in those processes. And so that's really who we brought together in our coalition, which is now called the California Restorative Justice Policy Coalition. And the first thing that we did was to understand what practitioners across the state needed and what their concerns were around legislation. And so we did focus groups and surveys of people across the state. And what really came out was that it was a few things around legislation. One is that practitioners were really in need of robust state funding that had no strings attached. every organization felt they could have greater reach with more funding and have that be supported through state legislation. There are concerns about funding being tied to certain requirements for restorative justice programs, but I can get into the concerns later. The other thing that practitioners mentioned was that they wanted to see the elimination of eligibility barriers. So there have been quite a few studies that show that restorative justice really works most effectively with violent incidents and more serious incidents. And so making sure that restorative justice is available to all rather than legislating around narrowing the group of people who can access restorative justice. And finally, third, they also wanted comprehensive confidentiality protections. So confidentiality protections in law would protect anything that is said by anyone in a restorative justice process from being admissible in later court proceedings. And this is incredibly important to the restorative justice process because people need to be open and honest about the harm that they caused, and they need to not be fearing retribution from what they're going to say. And so that was really important for practitioners in the state of California, and I think across the country. And then finally, one of the big concerns was a fear around co-optation and worrying that legislation would lead to systems actors being in control of restorative justice rather than having community-based organizations really taking the lead. Worried that legislation could lead to a professionalization of the career path of restorative justice that can often exclude people if you need expensive certifications or trainings, and a concern that people most impacted by the criminal legal system would be sort of cut out of being able to be a part of these processes. So that was sort of our first foray into the research, and I'll talk really quickly about the bill that's moving forward in California before I pass it along. So the AB 60 is an assembly bill sponsored by Assemblymember Isaac Bryan in California, and it provides victims with the right to be notified of the availability of community-based restorative justice programs and processes. The goal of the bill is to increase awareness about restorative justice and to empower victims and survivors to advocate for RJ for themselves if they so choose. It is anticipated that this bill will pass, and the coalition really feels like what is most important is how it is implemented. So questions remain of how will victims and survivors be notified? When will they be notified? By whom? How will people talk about what restorative justice is? It's very important that people understand and communicate accurately the power and the process of restorative justice. So who will be doing all of that? So the coalition is prepared to be very engaged in how this right to notice is operationalized. So I'll stop there and happy to answer questions.
Awesome. So I'll just pop it to Tarek to also give a bit of an introductory statement, and then after that, we can go right ahead into our conversation.
Thank you, Ink, and thank you, Alicia. So there's a lot to say on this topic. Honored to be here. I'm going to try not to repeat some of the things that have already been said, although I think they're worth reiterating. So maybe I will. Let me go through my notes here. First of all, I want to give my sense. Well, before anything, I want to say that, like, in terms of understanding the legislative landscape nationally, I highly recommend, following up. I'm going to put in the chat box here an article by Talia Gonzalez, who unfortunately wasn't able to join us yet, at least, that looks at an overview of what's happening in the states in terms of legislation. I can tell you from my perspective, which has been mostly on the East Coast with the exception of Nevada and Utah, that mostly what's been happening legislatively is that you have some really localized, robust implementation by non-governmental and increasingly governmental agencies in restorative justice. That's happening primarily in two areas. It's happening in the criminal system and in the educational system. Legislation, when it exists, is limited and in some ways is supportive. It doesn't mandate things. It doesn't provide much it doesn't actually address some of the legislative issues or blocks to restorative justice. At least this is in my experience in the DC, Maryland, Virginia area. And it doesn't provide budgeting, which is an important part of restorative justice growing legislatively. In terms of one thing that really needs to be noted in terms of legislation is that there is a profound danger in legislating restorative justice and having it actually undermine restorative justice. We're seeing this in a number of jurisdictions, particularly in the education space. So legislation is being passed that is incomplete, that sets unrealistic expectations, and that is unfunded, and is requiring particularly like school districts to work miracles. And when they don't happen, then restorative justice is getting a bad rap. For me, this comes closest to home in the Clark County School District in Las Vegas, where I've been doing work in Nevada. And what we're seeing there is an uptick of violence in schools. Very concerning, not to minimize this as an issue at all, but similar to what's happening across school districts in the country. A lot of it related probably to pandemic effects and other stressors, but that is now being attributed to pre-pandemic legislation, which in the Clark County and Nevada state context wasn't well done, the legislation in terms of restorative justice. So I can't emphasize enough the importance of being very thoughtful with restorative justice legislation. And I'm going to get through a few recommendations. I do want to note also that there's a tendency to assess restorative justice by a completely different standard than what we hold the criminal system or the educational punitive zero tolerance system to, the exclusionary discipline system to. We're expected with restorative justice to have perfect outcomes. We're not expected to have any recidivism. We're expected to see short-term gains. We don't expect that of our traditional systems. And I think it's time to shift the narrative, if anything, to ask for us to be comparing apples to apples. Should I go into some of my recommendations now, Inc., or leave that for the subsequent?
We have time, so yeah, spend a minute or two.
Okay, so a few high-level things, and maybe we'll get more into the details. High-level principles: make sure that when you're legislating for restorative justice, one is make sure that there is access to adequate resources and support, that you're not requiring implementation of things that take budget and time and personnel, and there's no support for whether it's a school district or it's a criminal system to be able to get that. Two, allow for adequate time for implementation. Don't require restorative justice implementation in a school district over the course of 1 or 2 years and expect the outcomes that come along with that in such a short time frame. Have a 5 to 10 year vision. That's usually how long it takes place. It's needed in order to implement well and start to see the long-term results. Number 3, avoid imposing restorative justice implementation, particularly on systems that are resistant to it. Instead, supporting those who naturally want to go and integrate restorative justice, and then letting the successes in those places spread out organically. Finally, avoid a kind of checklist approach to restorative justice. Do A, B, and C. Make sure you have this number of trainings. Credentialing is an issue that Alicia brought up. I agree with. And look at principles. Really make sure you're able to capture the principles of restorative justice that are more than providing a particular service. I'd like to speak more to the needs within the particular criminal education context, but maybe I'll hand it back up to you, and I'm sure those will figure into the subsequent discussion.
Yeah, definitely. So thank you, Tarek and Alicia, for those really helpful and really focusing opening statements. So I have a few questions for both of you, and so maybe I'll ask you first, Tarek, based on a lot of this work that you've done and these experiences across a variety of spaces in the legal system, and you just kind of touched actually to kind of anticipated this question by saying that a focus where there's there's already support for restorative justice than rather than where there's resistance. So in your experience, what have been the institutions, agencies, and the like that have been more open and receptive to restorative justice policies and principles, and which are the ones where you've encountered more pushback? And is there any trend across locations, or is this something that's varied across states and jurisdictions?
Yeah. Again, not really being able to speak to the sort of nationwide landscape, and referring you back to Dr. Gonzalez's work. From my perspective, I see an incredible emergence since George Floyd of progressive prosecutors who are actually really pushing restorative justice in many ways. I have incredibly awe-inspiring stories in some of the work I've been doing in Virginia, particularly with the Commonwealth Attorney in Charlottesville, Albemarle County, and Arlington County, of prosecutors who are even willing to take from their own budget to support restorative justice diversion programs. So I think that's certainly not true for all jurisdiction, but there are many. I think that there's a lot of potential these days, at least coming from the prosecuting offices itself. And I would be remiss if not to mention what's happening in DC, where the Office of Attorney General since 2015 has set up a very innovative in-house restorative justice program, where there are now, within the next year or so, scheduled to be more restorative justice practitioners working within the prosecutor's office than attorneys themselves. And it's shifting the culture of the office itself. They're expanding into young adults, and even catching the eye of the federal, the district attorneys, and in referring cases. Another place where I see restorative justice agencies is certainly in the school sector. So we have certainly school and school leaders, public and charter particularly. They tend to have more sort of freedom and mobility to innovate, but in school systems as well, you see a lot of potential, I think, for restorative justice coming on. Where things go slow is typically in the courts, working with judges. Police departments, it's mixed, but largely police departments are very slow to pick up on this, particularly when we're dealing more serious or adult cases. That said, juvenile justice agencies have been very receptive and have been part of the restorative justice kind of movement for decades now, in various pockets around the country. So keep it at that.
Yeah, thank you. Maybe bringing Alicia into this conversation a bit. So Tarek, you mentioned restorative justice practitioners in the Attorney General's office. And so Alicia, I know you were talking in terms of your work with the California Restorative Justice Policy Coalition, this fear of co-optation, whether in the legislation itself or in implementation. And so I'm curious, so I guess this question, one for Tarek, like, how do you counter that sort of co-optation when you have that sort of closeness between current systems actors and then restorative principles and practitioners? And then Alicia, in your experience, how have you and advocates in California looked to combat that sort of co-optation, both in the bill writing process, and then also afterwards when the bill is written, and then trying to make sure that the implementation of it actually looks like what actually represents the values of restorative justice?
Yeah, it's a really hard thing, and I dropped a link to our report that does a little bit of tracking of the ways in which various states have kind of really, through law, encouraged the integration of the criminal legal system with restorative justice. And there's much debate about whether restorative justice should be included and embedded and an option within the criminal legal system, or whether it should be a true alternative. And I don't think people across the board who identify as restorative justice advocates or practitioners agree necessarily. But within the coalition here in California, there seems to be very strong agreement about trying to keep restorative justice in the hands of community, while at the same time understanding that systems actors are referral sources. So I think what a lot of people are trying to think through is, if you get a referral for a restorative justice case from a district attorney or from a law enforcement agency, how do we limit information sharing with those agencies? So either through confidentiality protections or other protocols, how do we ensure that there's no racial bias in who's getting referred to restorative justice and who's getting referred to the juvenile or criminal system? So some of the ways that folks have fought back against racial disparities is by just saying, okay, every robbery is going to be referred to restorative justice. So that racial bias doesn't show up, and who's deemed as appropriate for restorative justice. So I think these are really big concerns that legislation could sort of feed into. One of the most interesting things to see in legislation across the country is a lot of the budget bills really tie in requirements for people to have a collaboration with a prosecutor's office, for example, or have a referral source from prosecuting or law enforcement agencies. And the coalition here is saying, we don't really want to legislate around that. So one of the ways in which that came up in our right to notice bill is really thinking through who is communicating the message, right? And of course, law enforcement are the people, for the most part, who are the first point of contact after an act of violence has happened. And so thinking through, like, what are the resources that law enforcement can give that speaks from the voice of community-based restorative justice practitioners, because people may be reluctant to participate in restorative justice if it's recommended by law enforcement, if there is a relationship or history of distrust within the particular community. So really thinking through, how do we notify people? How do people understand that restorative justice is really supposed to be community-based and victim-centered and really focused on the needs of each particular person involved in every incident, and that it's very flexible and oriented towards what has just happened for every different person. So I just wanted to mention also that there's one piece of legislation in Illinois around school-based restorative justice that explicitly says that the restorative justice grant funds cannot be used to increase the use of school-based law enforcement or security personnel. So there are some states that are kind of explicitly saying, we're going to try this different way, and we're going to do that by expending funding and not putting that funding in what we know has traditionally not worked.
Should I jump in? So I'd like to say a few things following up on issues of equity. I've broken down 7 fairly common equity issues that arise, particularly in the context of criminal diversion programs. And I'll try to just sort of run through those quite quickly. So first of all is the issue of net widening. When RJ referrals are made for cases that wouldn't otherwise be prosecuted. And so important piece there is the way we've dealt with that is through our memoranda of understanding with the referral sources, that they're committing to only send cases that would otherwise be charged and prosecuted. Second equity issue is referrals being made as early on in the criminal process as possible, ideally pre-charge, in some cases even pre-arrest, and certainly before there's a record that goes into the files. This is to avoid the hardship and trauma that involvement in the criminal system has. I will say, though, that sometimes it makes sense to have exceptions to this in order to allow for referrals also to be made post-charge. There might be institutional reasons to do this. There might be sort of political sensitivity reasons to do this. The key, though, is, are you seeing eye to eye with your referral sources that you're gradually moving towards as early on in the process as possible. So are you sort of in step, aiming towards pre-charge diversion as much as you can? The third one, referrals are not leaving prosecution referrals to prosecutorial discretion when there's a bias, again, particularly against people of color and other marginalized identities. This is in part issue of data tracking, like being able to track who's getting restorative justice, being referred to it, what kind of cases, etc., and then being able to go back to your referral sources and make come up with fixes to that. At the sort of extreme end of addressing this is doing what is being done at the DC Attorney General's office, which is having automatic referrals. They actually do this as part of their the randomized control trial. So no individual is making a decision. It's randomly assigned to either restorative justice or prosecution. So there isn't room for bias, and they're actually able to compare the results of restorative justice to the criminal process. Next is the quality and outcomes of a restorative justice process not being subject to the bias of facilitators, restorative justice programs and facilitators. This is an issue for restorative practitioners to deal with through trainings, through making sure that they have representative facilitators that represent the various identities they're working with. It's doing the work of understanding one's own biases and being open to feedback and so forth. Number 5, referrals, making sure that the referrals can be sourced from the community, so that there's access to restorative justice that's not just through the criminal system, particularly for immigrant and other communities who are reluctant to go to the criminal system. Number 6 is making sure that as restorative justice frees up resources, because we're taking cases for a fraction of the cost of the criminal system, that the budget that is now not being used by the criminal system gets redirected into non-criminal services, mental health, social public benefits programs, support programs, etc. And number 7 is that being careful that a restorative justice doesn't bolster the legitimacy of the criminal system in such a way as to lessen the political pressure on decriminalization, decarceration. This is the trickiest one. It's very abstract. I've been lucky enough to work with prosecutors where we can have frank conversations about this. Prosecutors who at the same time are playing their role, understandably, as within the criminal system, at the same time as we can talk about a vision that actually reduces their role. And that is possible by virtue of our relationship with those prosecutors, which is something hard to do if we were just advocates and activists. We build relationship with our prosecutors. We've even, in Charlottesville, put on informal off-the-record dialogue to talk about abolition with our prosecutors present and community members. That's the kind of stuff I think that allows for the sort of trust and being able to move together towards a larger goal of reducing the carceral system.
Right. Thank you for that. It's all really interesting. Alicia, you had spoken earlier about the fears of professionalization that had come up when doing the focus groups and the surveys in California. I was wondering if you could speak a little more on that, and how can legislation actually sort of shield from those sorts of fears of over professionalizing, especially given I'd imagine this tension between wanting to, track things and make sure that things also are a bit more formal, more in line with the way the traditional system usually works. So just how do you navigate those tensions?
Yeah, I think it's important that legislation not really set up that criteria for who is an expert or what makes somebody an expert in restorative justice. One of the things that coalition members really talked about is how that it can often exclude people from indigenous communities across the state who have maybe been engaging in, very similar processes within their communities, but aren't going to be either calling it restorative justice or officially formally trained. I mean, there are very few formal training programs or certification programs anyways within the United States. And I think one of the most important things about restorative justice is that it is really rooted in a sense of what we know about each other, what we know about our communities, and the expertise that we grow from being in community with each other. And it's not really something you can measure, and so it makes it hard to legislate around. And so I think it is probably one of those areas in which legislation just needs to stay away from, and not really encourage criteria around who can practice restorative justice, in the same way that it really should not be limiting who has access to restorative justice. You know, there are many statutes that talk about, you know, restorative justice is for first-time, nonviolent individuals, you know, with no prior criminal history. And in fact, you know, I think it's one of those things where, you know, we're practicing insanity by doing the same thing over and over to people and expecting different results, right? And so somebody who may have an extensive record of arrests or convictions may do incredibly well in restorative justice, right? And so I think there are certain things where we need to understand that the way that we've been doing things is not working. And part of that is because legislation has been such a driver of both criminal legal system reforms and sort of retrenchment. And so how do we kind of re-envision legislation in a different way, and also, you know, really only legislate around the things that community organizations feel are really necessary to protect their work, while, you know, leaving the rest alone, basically, and not creating unnecessary rules where we don't need them.
Awesome. So for both of you, I'm curious what in 2023, I know, for instance, Minnesota recently passed some restorative justice legislation. So I was wondering, kind of on that note, are there any recent promising trends or legislation that y'all, of course, besides some of the legislation y'all have already mentioned, that you see in the works across the U.S., and what do you think the policymakers and lawmakers could learn from some of those efforts that have been going on right now?
You want to start us off, Alicia?
Go ahead.
Okay. So if you don't mind, I'm going to mention actual legislation that's happened, and then wishful legislation that I'd like to see happen. Again, I don't have the national overview on what's happening outside of those particular states and jurisdictions I've been most involved with. First of all, Colorado has led the way in many ways in legislating statewide, and I put a report into the chat box that talks about some of those things. Happy to go into more detail on what exactly that legislation looks like. But let me, on the education front, I'm proud to say that I was part of an advocacy coalition that brought to pass legislation that I think restricted the use of exclusionary discipline in DC schools to an extent that's probably greater than any other jurisdiction that I'm aware of. So really limiting the use of expulsion and suspensions, other than a few very narrow categories. This, of course, pushed schools to have to figure out alternatives, and it was coupled with a student fund or a school climate and culture fund that was meant to support schools who are interested in using restorative justice or other modalities in face of this legislation. I'd say the fund didn't do as much to provide those resources as it should have. In terms of what I'd like to see in legislation, I'm going to underscore what's already been mentioned. Alicia talked about the importance of admissibility, confidentiality, protecting the safe space that restorative justice system sets up for participants to talk honestly about what they've done without worrying that that's going to get back into a legal adversarial process. Included in that is mandatory reporting. And we were able in Virginia, at least by decision, interpretation from the lawyers that are prosecuting partners' offices, to exclude our restorative justice facilitators from mandatory reporting laws. At the same time, we thought very carefully about what are alternatives to mandated reporting. If our facilitator knows about harm that's going to happen, we don't want to just leave them knowing that and not having an alternative approach to that. So we developed a whole kinds of guidance around that. And if anyone's interested in here, I'll have my contact information. I'm happy to share. Similarly, guardian permission. This can be on a legislative issue. Young people who might otherwise need guardian consent, I don't think in some cases they won't go through restorative justice if they do, because part of the issue is their relationship with their guardians. The toolkit that you all at Deepen have around restorative justice puts forward a number of very useful, statutory rights to restorative justice, notice, etc. I'd say a big issue is budget, and so appropriating money for restorative justice, taking money that goes into the criminal system that's as sustainable as it is for the criminal system into the restorative justice system. This is what one of the things that Colorado was able to do. I want to say in the education space, very important, in addition to the legislation I mentioned in DC, very important is to, besides legislating limits on exclusionary forms of discipline, is really encouraging whole school implementation. So not this sort of piecemeal, like we're going to have what we've seen in Nevada, for example, disciplinary program, required disciplinary plans for each school, but really pushing schools to think about the whole school climate and culture approach, changing the nature of the school, sort of organizational development. That, I think, makes restorative justice much more sustainable in the school context, instead of just diverting cases, disciplinary cases, or doing circles in the classroom. This whole school implementation is something I've had quite a lot of experience with, and I'll put a website for anyone who wants to know more about that. And finally, I want to speak to Title IX. So in the post K-12 context, we've seen Title IX go in various directions. Under the last administration, we actually saw Title IX open up to more restorative justice processes. I'm not sure that was intentional, but now restorative justice, particularly for cases of sexual harm on university campuses, is more possible. But there are still ways in which the regs hold it back. In particular, I'll name that currently Title IX requires an official complaint to be filed before you can have a restorative justice diversion. That can very much undermine a restorative justice process. Hopefully the new regs coming out in October will fix this, but I doubt it. But that's something I would like to see changed.
Right, great. Alicia, I just want to point out really quickly, if y'all could fill out a poll that's in the, I guess, on the poll tab, if you fill that out, and then I'll just leave it to you, Alicia, to wrap us up.
Yeah, I don't have much to add. That was all really excellent. I think just in terms of legislation that I've been seeing, I have seen a greater proliferation of confidentiality legislation, which is very promising, particularly in Massachusetts, which protects the very fact of participation in restorative justice from disclosure, and Texas, which protects the conduct and demeanor. So not just the words, but how somebody shows up in the space as well. So there's been some creative, interesting things happening throughout legislation. I know Oregon just passed a confidentiality statute, and Illinois, I believe last year or the year before, passed one. So we are seeing greater attempts at protecting confidentiality, and that seems really promising. I think the concern is that some of these statutes, again, may constrain ability for organizations to practice, have their practice be very rooted in community. And so we just really need to look out for that, and not using other pieces of legislation to restrict the way that community organizations have been doing their work for decades really effectively.
All right. Thank you both so much for taking the time to speak on these really important issues. I think we have I think there's another event for Statehouse Futures happening now. So if people want to transition to the stage tab to check that out, please do so. But for Alicia and Tarek, thank you so much for your time.